and esteemed colleagues. Good morning, and it's as usual and as always a pleasure for me to come to this institution and share my thoughts. And today is no different, except that the topic that we are discussing today, or where I would like to share my thoughts, is both a stock-taking effort and at the same time a forward-looking exercise, particularly because on this occasion I'm having the privilege of speaking to faculty members. Legal research in many ways can be described as, a nervous system for the legal discipline itself. And why do I say that? Because research informs your curriculum, designs your pedagogy, it shapes legal practice, guides judicial decisions, and most importantly, it influences public policy. And therefore, it is natural and it is important that legal research continuously evolves over time. And as we see today, therefore, when the today's objective is to discuss how it has evolved and what are the current trends in legal research. But even before we begin that, one thing that we must remember is ultimately the purpose of research, however, is still constant. And what is the purpose of research? The pursuit of truth. Professor Ishwar Bhatt in his book on research methodology has, very nicely quoted the verses from Ishavasya Upanishad as well. Hiranmaya patrena satyasa pahidam mukham tattvam kushanna pavarus satya dharmaya drishte. What does that mean? It is basically an invocation to the sun god. The invocation being that, O Lord Kushanna, please remove the golden light that blinds my eye. Why? So that Satya Dharmaya Dhrishtaye, so that I may see Satya and Dharma. That to date remains the objective of research. The pursuit of truth for the realization of Dharma. While that as it may, that remains constant. And probably on another occasion we can have that discussion between the interrelationship between Satya and Dharma. But while that objective remains the same, the path to that truth has to keep constantly evolving, changing, and stay up to the times that we live in. And that is the focus of my today's, talk. Because we live in an age that's so fast moving that yesterday is too late. And tomorrow is always here. And I can tell you, as faculty members, I have to, I cannot overemphasize this fact that when a student enters a law school in present times, in 2025, when he enters the law school, and by the time he steps out of this law school in 2030, legal education is going to be completely different from what we know. So it is not sufficient that we make him or equip him to deal with today's challenges, because 5 years from now legal research is going to be completely different, and that is the focus of what I intend to talk about. And therefore, research must become anticipatory, collaborative, and most importantly, socially responsive. And let me therefore begin by acknowledging the evolving nature of legal research. I mean, earlier, up till a few years ago, legal research was primarily doctrinal in nature. And a lot of focus was on what the law should be and how it should be. It has been changing, yes. Even today, and that is a point which I would be, summing up in my conclusion as well, that while the focus now has moved to a more empirical nature in study, doctrinal research has its own relevance. The need of the time is only to modernize doctrinal research, not just abandon it. But we'll come to that in a minute. But, it was only yesterday when Sir actually asked me if I can actually this. I was supposed to come here just for an open defense viva, and it wasn't, part of the plan to talk. And then Sir asked me if I can also speak. I told him yes. So I had to then start thinking, what am I going to, share with my colleagues here? And quickly, in the back of my mind, therefore, when you look at current trends, there were three major trends that I identified. One of which I don't intend to speak too much on it, because that has already been, employed by most of the good institutions, including this one, which is the shift to a more empirical study. I think all of this, in fact, the thesis that is going to be subjected to an open defense today is all self and empirical study. But I just pointed that out here today because it is a trend, it is a need of the society today to move to an empirical analysis and data-based research to scientifically establish certain truths. And it has its own challenges, which I will talk later. But there are two other trends which I would like to emphasize on. The first is interdisciplinarity. We all know that law, of course, does not exist in a vacuum. And law is simply a means of a social or a tool for social control. And therefore it pervades into every section of the society, every sector of the society. And therefore a truly effective way of conducting a research will require a researcher to have knowledge of these allied disciplines as well, in equal measure, if not more at times. And even when we say that our approach has been at least a few years ago, well, law has to closely interact with economics, sociology, political science, and so on and so forth. But today, even that is not the case. No, it's interesting. At my law school, we are presently undergoing a curriculum revision. We do that once every 3 years, and therefore this 2 months we are spending on curriculum revision. And just to give you an idea of some of the papers that we are now introducing, I have a course on emerging technologies, not law, to be taken by a faculty from the College of Engineering, which deals with the fundamentals of blockchain technology, IoT, right, and cybersecurity. Because if my student is supposed to play a role in regulating blockchain through a law, if he has to play a role in bringing a law to regulate blockchain, how does or how can he do that without understanding how blockchain functions? If he has to lay down the policy for IoT security, how will he understand that unless he knows how Internet of Things work? Where is the weak link? Unless he knows that, it becomes difficult. So, emerging technologies is a paper. Design thinking is another paper. These are papers which a law school is going to do. Because design thinking is not merely associated with product design. If I, as a law student, am going to play a role in policy making or find solutions to the problem, what is it that I am required to do? I need to come up with a design, a policy design. And the same principles of design thinking, which is, empathize, ideate, test, prototype. That's the design thinking principles that you will find. The same thing applies here. You first have to empathize with the victims, and then ideate and come up with a policy law, then go study, do empirical study and test and build your prototype, the draft law. So this interdisciplinarity has become imminent and imperative in legal research as well. If our research has to be truly impactful. But then we have a problem. Particularly, that's not as much a problem perhaps in the UG studies, but the major part of the research happens much later. The master's level, postgraduate level, at the doctoral level. And there we have a problem because our system, educational system itself, have always been severely compartmentalized. The NEP has made some significant changes to that, but then that's going to take still some time for the students who are now in their lowest grade schools to experience the proper, effective, implemented policies of the NEP. That many places are still not implemented. So it will clearly be another 15 years before those kids come to the level of postgraduate or doctoral studies. And the people who are currently doing that course, they have been severely compartmentalized, which handicaps, even if we want. I would like, last year one of my scholars completed and he was awarded his PhD. He was the head of legal division in Zoom, online meeting platform. And his PhD was on liabilities in case of accidents in automated vehicles. It's basically dealing with AI, the versions of it, and how to impose liability on it. He was a former wing commander as well in the Air Force. Now, I would ideally like such researchers to come up. But what is my competency when I seek to try and, mentor? What is my ability? Because I don't have a technology background. Well, one option, therefore, that we could look at is to have co-supervisors. I have a technologist as a co-supervisor. So that is still doable. Where I, as a supervisor, fall short, I can seek help from the industry. But what about the guy who is doing the research? That person also needs this interdisciplinary knowledge if he has to do the research. But our education system has been such and has been so severely compartmentalized that it is, at least for the present, proving to be a very significant hurdle in making research truly transdisciplinary or interdisciplinary. Most of the see, if you see a lot of interdisciplinary work has been happening with law and sociology, or law and political science, including the thesis that is up for today's open defense. Why? Because BLMU was started somewhere late in 1989. You can see the results now that's happening, that there's a lot of interdisciplinary studies happening where you're there's a lot of interplay between law and these social sciences. But the fact is that today's society requires not just, interdisciplinary approach in these disciplines, but across all disciplines. So yes, it will change. The title is also about hope. It will change. But then this handicap of the times that we live in, we as faculty members need to be conscious of this handicap. Only then we start cultivating and finding remedies for us. So that is the second of the trends that I think. The first, of course, was about empirical legal research, which, as I said, I don't intend to talk, too much or in great depth, because that is something that all of you do realize. Second, of course, is interdisciplinary, but the third, and again, something that deserves a lot of attention, critical for faculty members to understand this, which is the proliferation of artificial intelligence and how it has changed the entire landscape of legal research. Not just legal research, any research. And to understand the present, of course, we need to go back and look at the past as well. And legal research at one point in time meant that you have to pore over pages and pages of dusty digests. I remember Sir was referring to the fact that, he had visited my college when I was a moot court coordinator at that point in time. During those days, I was an active mooter during my student days. We had to prepare for Jessup and Stetson, go all the way to ILI Library in Delhi, British Council Library in Chennai. I did my law in Kerala. Right? So I had to go to Delhi or Kerala, to Bangalore here in the NLSI library, to access books, to read books, to prepare. That was research for us at that point in time. And then there was a revolution where you had all these digital databases. Manubhadra, Westlaw, LexisNexis, which made it so easy to find all the cases, materials, and sometimes even scholarly articles in these digital databases. But boy, today, we used to say, therefore, it's all just at the tip of our fingers, we just have to type and you would get. That is what we used to say when the digital resources came. Today, you just don't even have to type. Ask Alexa, ask Gemini, in plain English, and you have all the NLPs, natural language processors, to give you a very structured response with all these materials. So what's going to happen to research? PhD should then be so easy, isn't it? Just tell Alexa to give me a draft thesis. Might work, you never know. No, doesn't work that way. Today, therefore, as I said, you have even these digital databases, therefore, have its AI functionalities incorporated into it. So you have Westlaw Edge, which is an AI. You have Nexus Plus, SEC Online. All of them have now inbuilt AI functionalities incorporated into it. Case mining. Literally, therefore, mines you through a lot of cases and gives you the relevant cases, throws it up for you to study. They've all started integrating AI functionalities to help students and legal professionals conduct faster and more accurate searches. Now there are even a lot of software and apps that use AI to help us even review documents. So, in a law firm, Sriram for example, has already, they have Lucio, they have already incorporated ChatGPT Plus. As I remember, they even started a Harvey AI on a pilot basis. They've incorporated Harvey AI also. These are AI tools which law firms have now invested in. As faculty members, what we need to understand therefore is, how do we now move from here? Do we tell our students therefore to stop using ChatGPT? No. Because Sriram will ask you, are you familiar with it? Well, then do you give access to them? Then what's going to happen to all your assignments that you give the students? How do you assess them and what is it that you're going to assess? See? And remember, that's why I said, in 5 years from now, there is going to be a lot more automation happening. A lot more softwares happening. Almost every other person worth his name or salt is thinking of AI. I have engineering students in my law university meeting me at times. Why? Because they are trying to build an app which will analyze all kinds of disputes in a court and predict judgments. I have a fellow in my office who comes, he's an engineering student, right, who keeps coming to me to show his prototype, asking for feedback. In such a scenario, how do we equip students? How do we make them enable for placements? So we can't keep this technology away from them. And yet we need to ensure that the tool does not become the master. We still have to hold the arts. And how do we ensure that? Is the challenge. And I'll tell you, so what I was trying to refer is, earlier when our students go as a fresh graduate and enter a law firm, what does he do? Research, basic research. Partner will ask him, bring me cases on these points. Or basic review documentation. Maybe after a few months, he even does a due diligence report for by examining all the documents in a company. These are the things which a fresh law graduate who enters a law firm does. Many of you have had experience after your law in joining a law firm in the very first year. This is the kind of work, or if you have been an intern, you would realize these are the works that you do. Well, smell the coffee, because that job is not existing anymore. That's being done by your AI tool. Document review is done. Research, throwing up case laws is done. Due diligence, done. What can your fresh graduate do? What can researchers then do? Research now, what will happen to the plagiarism report? How is it going to be analyzed? What is it that you're going to assess now in a doctoral student? These are the questions that require answers, or at least every faculty member should be thinking about. And the first thing that we need to understand is, AI mimics reasoning. And I use my words very carefully. Artificial intelligence only mimics reasoning. They don't reason. It cannot reason with you. It cannot. The problem is when we keep talking to Alexa, after some time we think Alexa is a friend. We personify it. Certainly forgetting the fact that it is after all just a goddamn algorithm. It cannot reason, it can only mimic reason. That is the reason why many times ChatGPT will give you a wrong answer because there is a judgment. It can pick the judgment, but it cannot call out the ratio from it or distinguish the obiter from the ratio. That requires this material which is between our ears. That can't be done by this algorithm. Of course, unless it is specifically trained to. ChatGPT is a generic tool. There are people who are trying therefore to work with specific feeding in precedences of how you call out the ratio from a judgment, and you train that software adequately so that there is an acceptable accuracy ratio when you can try and see whether you can call out the ratio. But the point that I am trying to impress upon you therefore is artificial intelligence does not reason, it only mimics reasoning. This we must internalize. We can use ChatGPT therefore, but only with human supervision. When that doesn't happen, that is when, and it's, sometimes we refer to last month, wasn't it, that the Singapore Court of Supreme Court had set aside Justice Deepak Mishra's Arbitral Award, right? That's not just unique to us Indians. I can assure you, the American Supreme Court has punished several lawyers for finding fictitious cases in their briefs. There was no such case, but unfortunately, ChatGPT had thrown up those names as cases. It was found there, and when the judge looked through the briefs and found a case and tried to retrieve that case, there was no such case. Lawyers were penalized in the United States. So we don't have to be, self-deprecating ourselves, thinking that this happens only in India. No, not in the least. There are therefore challenges even with artificial intelligence. What are they? I mentioned 4. I'm not going into the depths, I'm just giving you direction so that you can take this forward with the constraints of time. 4 major challenges with respect to artificial intelligence. 1, hallucination. ChatGPT is prone to hallucination. Hallucination is throwing up fake information because that's the algorithm. It is supposed to process certain data and from there create data without reasoning. Remember. So it is capable of generating false information, which is the reason why those lawyers were penalized in the United States as well. Second, and these challenges all of us should be very conscious about. Every researcher. Look, there is no harm therefore in relying on artificial intelligence. Rather, it's common sense that when you have a tool with which can help you save time, you must use it. The problem is when you start using it blindly without supervision. So the first is hallucination, the second is bias. Quite clearly, the algorithm predicts only on the basis of the materials it was provided with in its training phase. In some of the states in the United States as well, there is a software, if I remember correctly, its name, the abbreviated name was called as Compass. I can't now remember what its full name was. It was something relating to correctional facility, because this software, what does it do? It used to help in deciding for prison officials whether the person can be sent out on parole. Right? So prisoner who's there, based on his report of his stay so far, can he be sent out on parole, or can his sentence be commuted, etc., etc. To decide that, they use this tool, because this tool contains the data of all the man-made decisions so far on whether he can be sent out on probation or not. Using that, you can decide very easily now whether this. But essentially, look what is happening here as lawyers. We are deciding this person's, whether this person ought to be sent out of jail or not, based on what? Based on all the conduct of previous people. Isn't there a bias? Let us say, hitherto, and we are talking of US, so I'll take that as well. Let us say, hitherto, in that particular jail, people of colored origin were denied bail. They were denied bail not because of their color, but because of their behavior. But they also happen to be, let's say, of colored origin. The algorithm would take that as a training. And if this person who is now subject to a decision is of colored origin, that bias affects this person's right. He might not have misbehaved in any way. But that's artificial intelligence. That's bias for you. So AI is inherently susceptible to the bias of the previous data with which it was trained. So we need to be conscious of it. We can use it. But then the person using it cannot blindly rely on the decision. It will have to see this is the reason, so there could be a bias, and then do what is required to remove that bias. So hallucination, bias. Third, of course, confidentiality. As a researcher, I am collecting a lot of personal information as part of my data collection. Of course, if I am collecting that, my questionnaire ought to have been vetted by an ethics committee. Yes. I collect data, medical records, for example. Now, to analyze this data, suppose I put this into an AI tool, a ChatGPT or a Gemini or a Copilot or whatever. Who's going to secure the information? I've just put it up there. ChatGPT is run by a company called OpenAI, for Christ's sake. Where is the security for this data? So there are huge confidentiality concerns with respect to information that is. Right now we all use ChatGPT, isn't it? At times. And for ease of information, therefore, we give a lot of information to those tools. All those informations become the material for its training again. So every information that we got from ChatGPT is based on a reciprocal transfer of information from our end, which now we have no control over. The Ghibli photos, we all enjoyed them. How did we get that? By uploading our photos first day. Why did they come up with this? And there's an interesting anecdote, you must understand this. For some other work, they require to study patterns, human face patterns. So what did they do? They came up with this idea of Ghibli, made it viral, made it a trend. So all of you voluntarily, all of us, me included, voluntarily uploaded our photos. So now they have a huge millions of faces for them to study their database pattern. they got what they want. Confidentiality. And last, of course, responsibility. Look, the bias, the hallucination, the lack of confidentiality all would be because of the algorithm. But who's going to be held accountable? The researcher or the lawyer. I gave the facts of the case into the ChatGPT. It drafted a brief for me. I presented before the court. The court finds that some of the cases mentioned there are fictitious. It's no defense that for me to go to the court and say that, oh, it's the algorithm's fault. No, it's not the algorithm's fault. You are supposed to oversee, so responsibility does. So it does all the work for you, but remember, without responsibility. Responsibility is on your shoulders, on your neck. It's your head that's on the line. We have to therefore be accountable and responsible in how we use the information that we get from ChatGPT. But having said that, as I said earlier, it's not all doom or gloom. It's all about hope and loopholes. There's a lot of hope as well, remember, because AI now has become such a great democratizing force. As I said, now I could go to Delhi, ILI library. I could afford to go to Chennai or NLSIU Bangalore. There are a lot of them who can't afford. Studying from the interiors of a Kottayam district or a Pathanamthitta district and going all the way to Delhi might not be affordable for everyone. AI has brought them access to those informations, right? Irrespective of, whether you are a hot, smart sought after lawyer in the Supreme Court or a lawyer in some trial court forsaken by everybody. Doesn't matter. Both of you have access to at least the free version of ChatGPT. Access to information is there. Many of the barriers, therefore, technical barriers, has been lowered to a great extent. Remember, they are all getting the same information. So, AI has helped. Collaborative research is now happening, as I said, with people from the industry also. So, the question of transdisciplinary or interdisciplinary studies also, there is hope still. If we can use that collaboration with the industry in pursuing. So, if there is a supervisor from this school, there can be a co-supervisor, let's say, from a Siemens or a Bosch. And that's not exact. My wife works in Siemens and she is a co-supervisor for a thesis from, I think, NIT Surat. This is being done. It needs to be explored by all of you. Get people from the industry to join you, partner you in mentoring research. That's when research is going to be truly impactful, friends. Student-driven research culture, again. Research is not something that needs to be done only at the doctoral level or to some extent the postgraduate level. Start right down. That culture could be a blog, but involving research. Our role as faculty would be to mentor, channelize, and critically shape the enthusiasm of the kids into a substantive inquiry. That should be a pedagogy. And impact-oriented metrics. And when I say impact, I know when we talk of research impact, we tend to look at either impact factor of the journals that we publish or where that journal is indexed in, whether it's a Scopus indexed or UGCK, but it's no longer there in the first place. UGCK. No, that is there for, there is some requirement and therefore it's there, but that's not the only metrics of looking at impact. And that's a crisis which India as a country is facing, not just in law, legal research. And what I'm referring to is 90% of the thesis that is being produced by universities in India, after the thesis is awarded, lies in the shelf of the library, and that's it. Somebody spent 6, 7, 12 years at times to work on something, has come up with the research. The scholar himself also, after he got the degree, therefore keep it there. When was the last time we all touched our thesis? Or went back to our topics? For those who completed their thesis. Thesis is being done for the sake of the degree. What a tragedy, imagine. We've spent 5 years of our lives. How much of that has been converted to a patent? I mean, in technology as well. How many of that has been implemented? In law, for example, how many of them has resulted into a policy making or a law? The challenges faced by laborers in Kottayam today, which is going to be awarded after the open defense. Is that information that was collected and analyzed with so much of effort going to lead to the betterment of that employee? We have to ensure it does. That's when thesis or research becomes impactful. We've stopped at that degree. Ho gaya, khatam, khalas. No, we should not let that happen. If research has to be impactful. And this is to be correlated with at the beginning of the research, when the supervisor also has to see therefore that whether the topic picked by the scholar has a potential to create impact. Somewhere down the line, why we today look at doctrinal research in a kind of unfavorable manner. We look at it with a lot of disfavor. Why? Because doctrinal research was used without too much of thought given to what impact it has. So you just picked up some theory, came up with some theory, you elaborated into a different theory and just got awarded a degree and it's lying just there with no impact. That is why people started saying, no, please go into empirical research, socioeconomic studies. Because this is useless. It's useless not because doctrinal method is useless. It was because the topics that we chose had no potential to make change in society. You think. Therefore, at that time, whether this topic has the potential to create social impact, and then once the thesis is completed and awarded, pursue that to its logical end and ensure that there is an impact. Of course, hope was there and finally the loopholes. There are challenges. One, as I said, there is a methodological gap. Even in empirical research, let me tell you this, in a lot of research is empirical studies as well. One common thing that I find in most of the scholars is the bias that is there in that study. We are not making it as rigorous as it's supposed to be. You know, the scholar should be the first person or the person who has challenged his own facts the maximum. Whether the data I have collected is free from bias. The problem is, I start with a hypothesis and right through my thesis, I somehow move with the fervent wish to establish my hypothesis. That is the first step of bias. Your thesis is no longer neutral. If I am moving, if I have worked 5 years for my thesis to prove my hypothesis, that's bias. I should be open to the fact that my hypothesis can be either proven or disproved. If it is disproved, fine. That is my thesis. That the common perception was this, but through my research I found that what even I perceived is wrong. This perception is therefore unscientific. That has to be my research. So I have to be objective and open. So the data that I collect, I cannot search for people from whom I can get favorable data. That's bias again. As a supervisor, I've seen that when I question my scholar on the data collected, she would think or he would think that I'm, creating problems for. No. If we don't challenge it, someone else will challenge. The data has to be, therefore, we have to ensure that it is. So the methodology must be a very rigorous one. As I said, doctoral research has been undervalued. It has its scope. The only thing is it has to be modernized. There are ethical challenges, integrity challenges, because of this requirement of, with a lot of the proliferation of AI, there is also, concepts like ghostwriting today. There are people who can write an entire thesis for you in one day. Not one day, even a few hours is more than sufficient. And as I said, PhD is ending in silence. It cannot. It has to be taken forward even after the award of the degree to something more concrete. Rest of it is something that, one more point before I conclude. Is the fragmentation part. As teachers, there is this increasing trend that, okay, I am a contract law teacher, so I will look at only contract laws for my research. But contract law might involve sociology as well, when we are talking of equality of bargaining power. Contract law might involve technology as well, when I am talking of e-contracts. As faculty members, we have to wonder that are we still speaking a common language? It can't be the case that I will only speak contract law, he will only speak criminal law, you will only speak family law. So, no, we all have to at least speak law. So there has to be a common language where we are connected. Our expertise, our different expertise must come together through a common law. There is an increasing trend now in, people fragmenting into different areas of law at the cost of looking at it holistically. So I will stop on that note with concluding that yes, legal research is at a very pivotal juncture now. None of us know how it's going to be 6 months down the line, let alone 3 or 4 years down the line. But what is required for us is for us to know how to use technology in a responsible manner, how to hold control in it and not to let ourselves, overtaken or subsumed by technology, and understand that research not only interrogates the law but imagines new possibilities for justice. Once we understand that, I think everything else falls in place. Thank you all for your patient listening and